let's talk about the motion that was brought to evaluate the legal filings of the North American Mission Board. This was a motion that was brought by a pastor with the intent of trying to help the Southern Baptist Convention as a whole, but those in the annual meeting to present and create this task force to evaluate what many are saying is a misrepresentation of who we are as Southern Baptists. Let's look real quickly at the arguments that were made, and then I want to get your comment on the other side of this, all right?
Microphone 1A, please state your name and your church, and we recognize you to speak against the motion.
Thanks, Mr. President. My name is Josh Revis. I'm a messenger from North Jacksonville Baptist Church in Jacksonville, Florida. Longtime listener, first-time caller. Just wanted to say this motion is both unnecessary and unproductive. I've been a trustee at NAMB since 2022. Motion is unnecessary because any Southern Baptist may already review every word of NAMB's public legal filings and oral arguments, and NAMB would welcome that. It's also unproductive. These task forces have a twofold cost. They cost regular Southern Baptists who get appointed their uncompensated time away from other things. It also costs CP dollars to fund them. And this matter that's at the center of this motion is pending currently. It's not complete. And so any study would be premature at this stage, and its findings would be incomplete. And I don't have any personal swag to give anybody, but I would like to give back 2 minutes and 8 seconds to the people. Thank you.
Microphone 5A, would you state your name and your church and make your argument, please?
Jonathan Jarbo, messenger from Pathway Church in Redlands, California. I also serve as a trustee as NAMB, and I just want to echo what Josh said and believe this motion is unproductive and will use cooperative program resources. The issue is still pending, and so a review at this point would be incomplete at best, and so I oppose the motion.
Josh, let me get your initial thoughts. What are your thoughts to their arguments at this point?
You know, I agree with the spirit of the motion made initially because I have the similar concerns just through the grapevine and watching what I've watched, listened to what I've listened, and read what I've read, and not being able to get necessarily in the weeds here, but it does concern me that if there's something that NAMB is doing on the behalf of other churches that then subjects us to potential lawsuits in the future or liabilities that we may be caught unaware by, I think that's very concerning. And I think it's right to identify those things as he has there on the floor. And now the hard question for me is how do we, what ought we to do about it? How do we bring accountability? How do we rectify the situation, determine whether the risk is real, how real it is, and then what to do about it? That's a challenging question. That's obviously what the other messengers were coming against, that this is an unnecessary way of going about doing anything about it. They were also minimizing the issue, and I think that's wrong. And I'm up for debate as to how to tackle the issue, but I'm certainly in agreement with the spirit of the initial motion made on the floor.
Yeah, and of course, this is where they're speaking to it. It's not when they made the initial motion, but the two that responded to say, "Hey, we don't need this motion," opposing it, they both were trustees of the North American Mission Board, and in my view, it kind of sounded like they're just pulling the party line. Okay, to some extent, they used some phrasing which maybe their legal counsel or somebody else helped them put together and make sure they were saying this a certain way. But they used the phrasing, "This is unnecessary." They said that the motion is unproductive. They said this is an issue that's still pending. Well, the motion, if I understand it, the motion wasn't about what's still pending. The resolution of the case is still pending because it's waiting on a response from the U.S. Fifth Circuit Court. And this is in the McRaney versus North American Mission Board case. So the case is pending. The issue for the motion is not still pending. The issue of the motion is we want to have evaluated the arguments that the North American Mission Board has made to the courts. And understand, this is multiple courts. It's been done to the Northern District, the U.S. Northern District Court. It has to do with the U.S. Fifth Circuit Court the first time, and now the second time, as they've said, there's an implied consent that NAMB has basically authority over a state convention through implied consent governance, and then also to the Supreme Court. North American Mission Board took it to the Supreme Court. And so the motion was, hey, look, none of that's pending. This is all documents that are publicly available and are now there. And they're saying, well, there's no reason to mess with that. You can look at it if you want to. We encourage you to do that. But this is not something that needs to be done right now, which is of real concern to me for a lot of reasons. Let me put up a slide that Randy Chestnut, a pastor in Ohio, put together. And we've shown this before on this channel. We have some other information about this, but some of the NAMB defenses that raise question, and this is part of what the motion was intending to have reviewed, I think, in these court cases from 2018 and 2022. NAMB had the legal right to interfere to protect its own economic interests. The pastor who was speaking for it brought out this. The 12th defense you see there, NAMB is protected by an absolute privilege with regard to any statements it may have published regarding the plaintiff, meaning McCraney. 13th defense, they're qualified by privilege with regard to any statements it may have published. 15th, plaintiff was a public figure within the meaning of the law, defamation, and therefore bears the burden of proof imposed upon public figures. And then the 16th defense, they say, NAMB is protected by an absolute privilege and or qualified privilege with respect to all decisions it made or actions it took which may relate to or had effect upon the plaintiff's employment with the Baptist Convention of Maryland, Delaware. That's what he's wanting reviewed. That's the issue at hand. None of that's pending. Those were all taken directly out of court documents. And then, of course, the arguments, like I just mentioned, that were just made before the U.S. Fifth Circuit Court on the 4th of April, those, is that right? 4th of April? Yeah, I believe that's right. Or May. Yeah, I think it was April. But when those arguments were made, they argued that there was an implied consent that they needed to abide by what basically the North American Mission Board's governance was, which doesn't line up at all. I mean, what are your other thoughts about that? I mean, do you think like this doesn't need to be dealt with at all until this case is settled?
No, the trustees' response that we're given there in that particular clip definitely make you feel dismissive. You'll also notice in each of their they like to throw a joke in there at the beginning or the end of what they're saying. It's almost like to try to soften things or to make it seem less significant or serious. Because the first, when the gentleman's speaking on his motion, he's very serious and very concerned. And then when you throw jokes in your brief little testimony there, that he's speaking also to it, that it makes it feel like you're being dismissive of the concern, and that raises red flags for me. And so, yeah, it feels very dismissive on their part.
My initial response when I looked and listened to the arguments, the NAMB trustees were very short, to the point, had a couple of talking points. They both kind of hit on those. It needs to be defeated because, right? And the one speaking for, it kind of got muddied to me. It got a little muddied in trying to present it, wanting to get a lot of facts in, get that information in. But it didn't seem to be near as impactful as what I think it really is, trying to help those messengers present understand this is a significant issue. And let me tell you why. We've talked about this a little bit before in some other conversations, but their arguments are building a connectivity with Southern Baptists. And in the sex abuse cases, in other kinds of lawsuits, any kind of case, when you start trying to connect, say, any of the entities or have some type of a hierarchical role, there's a connectivity between them, then when there's a lawsuit against a local church about whatever it may be an abuse case, but it could be simply somebody fell down the stairs going out of your church on a Sunday morning and go back and look at it. They realize, well, hey, that handstand's just a little bit loose. You know, the handrail is a little bit loose, and I fell because I grabbed that and I slipped when I fell and it wasn't steady, and I'm going to sue your church. Well, if there's that connectivity there, then the lawyer's going to say, well, I'm also going to sue that local association that you're a part of, and I'm going to sue your state convention there in Alaska, and I'm going to sue the entire Southern Baptist Convention because they're all connected. See, there's this connectivity, and the arguments that have been made, the ERLC before the U.S. Fifth Circuit Court last time used that term hierarchy in their arguments, and then North American Mission Board making many of these arguments, saying that they have a right, they have the privilege of doing that, whether they chose to or not. To me, is creating a legal precedent in ways that are going to be extremely dangerous and hazardous to Southern Baptists down the road in all kinds of cases, not just related to abuse and not just related to the defamation claims and other claims of interference that McRaney is making toward NAMB.